A leaked Home Office report called Rapid Sprint says you would be part of the right-wing extremist narrative if you made any sort of claim or comment that there's two-tier policing going on in the UK. It also suggests that the recording of non-crime hate incidents should be expanded, which I personally think is a dangerous curtailment of free speech and is probably against several existing laws, for example, human rights laws. So I'm going to talk a little bit about that in this video, why you should indeed be alarmed about it. I'm not being alarmist, but I think this really is alarming, to be quite honest. So if you like a brutally honest appraisal, objectively, from a barrister of England and Wales, please do subscribe to the channel, because I suspect you won't hear what I say through many other outlets. But I will talk about that in this video. So please do subscribe and I'd be very grateful. So let's take a look at these claims, shall we? Now, this is reported by The Telegraph, so I will link the original article below. But these things have a way of leaking out, and they are things that we really should be concerned with. Now, talking first of all about this section where it says, on the extreme right, this report says that claims of two-tier policing are where their two groups are allegedly treated differently after similar behaviour by the police. And then, thereafter. And it says that this is an example of right-wing extremist narrative, which is leaking into mainstream debates. Now, quite frankly, regardless of whether there is or is not two-tier policing going on around the country, or any kind of two-tier justice for that matter, that is sort of not really the point. The point really here is, if people have that view, and this is going to be important a bit later on, if people have that view and that perception of what is going on, that is their entitlement. They are entitled to have that view. They are entitled to express that view, even if it upsets somebody, even if it's alarming to somebody, because free speech does include that which may be alarming to other people. You've probably heard on a number of occasions police in various videos saying that if somebody says something that is causing somebody alarm and distress, then that is automatically potentially harassment or things of that nature. And at one point, just a few years ago, there was even a police billboard being paraded around on the side of a van that said, "Being offensive is an offence," with the pride flag on the left-hand side of that billboard. Now, that was patently false. Being offensive is not an offence. I'm not condoning being offensive. I don't want people to be offensive to each other, but that in itself is not an offence. And ultimately, Merseyside Police had to apologise for this billboard because it was a false claim. Now, one of the reasons I do these videos, and I would like you to subscribe to the channel, is because not only is the law and the system complex enough as it is, that not even every lawyer understands every area of law or every part of the system. We either have to refresh our memory or ask each other about these things. But with respect, how can we expect the general public to understand all of the law and what this applies? Now, if you see a billboard like that and you didn't see the follow-up article and the apology by the police that said that was false, you would go on thinking that being offensive is an offence. Now, again, I'm not encouraging people to be offensive to each other, but the point here is there's a very fine line between being deliberately offensive for the sake of being offensive, which, again, in and of itself is not an offence, but where do we draw the line? Because if you say something that somebody finds offensive, then obviously that still isn't an offence, but that is where we have to consider where this line is. Do we consider that wrong, or is that just part of free speech, everyday free speech? We have the right under Article 10 for the freedom of expression. And this has been dealt with a number of times, and this is where it conflicts, in my view, with the recording of non-crime hate incidents. I'll come back to those in a minute. But let's just have a brief look. This was a landmark case, Scotto and the CPS judgment here. Where this was in particular regard to harassment, which again it involved the use of speech and whether or not it crosses that threshold to what we will consider harassment. And it was put here that in most cases of alleged harassment by speech, there is a fundamental tension. Section 7.2 of the Protection from Harassment Act provides that harassment includes alarming the person or causing the person distress. However, Article 10 expressly protects speech that offends, shocks, and disturbs. So again, there is a balancing act to have here. And this judgment quotes, "Freedom only to speak inoffensively is not worth having." So in other words, we have the freedom to speak even if it offends somebody. Consequently, this judgment says where Article 10 is engaged, the court's assessment of whether the conduct crosses the boundary from unattractive and even unreasonable speech or conduct or whatever to oppressive and unacceptable must pay due regard to the importance of the freedom of expression and the need for any restrictions upon the right to be necessary, proportionate, and established convincingly. And so when taking any of that speech, anything you say into account, that balancing act needs to be judged, and judged properly. And it has been judged. This is a leading landmark judgment in the High Court that essentially said if you only have the freedom to speak so long as it doesn't offend anybody, then it's not worth having. But we do have that. We do have the freedom of expression protected as a human right. It's a qualified right, so you can't just say absolutely anything you wish. This is different to the United States. But nonetheless, it is a fiercely guarded protection. And much more so if you are speaking about political issues, philosophical issues, and even philosophical beliefs. For example, anything to do with biology, male and female sex, for example, these are now protected fundamental beliefs. And accordingly, the freedom of expression also comes into play. So coming back to this leaked report, Rapid Sprint from the Home Office, allegedly says that if you make claims of two-tier policing around the UK, then you are apparently part of this right-wing extremist narrative. And it also then talks about the expansion of the recording of non-crime hate incidents to include all sorts of different things. Now, again, I stress that I am not in favour of people being offensive to each other, but we have to draw this line somewhere, because you may share the view and you may not want people to be offensive to each other, but one day you might just be expressing a view that then somehow gets caught up in this definition, and they say that it's perceived to be offensive, therefore you've been offensive, therefore they record this non-crime hate incident against you. Now, these are not criminal offences. They are not recorded as a crime on your record as such. However, if you work in an environment, for example, that requires an enhanced DBS check, Disclosure and Barring Service check, usually when you work with children, for example, I teach martial arts, I'm a martial arts instructor, so I require an enhanced DBS check. Or perhaps you work in a school, etc., then you'd be required to have a DBS check, an enhanced DBS check. Then these would show up on those enhanced checks. Now, think of it from a prospective employer's point of view. You're going for this job interview. They do this, you give the permission to do this Disclosure and Barring Service check on you. And it comes back that you've got, let's say, half a dozen non-crime hate incidents recorded against you. Then we have to look at what those are and whether that's fair, because that employer may then not take you on because you've got these 6 reports against you. They don't want somebody who is quote-unquote hateful, because that's the description of this recording. Let's take a look at what this really means, because I think this is a curtailment of free speech, and I think it's against our protected rights, and I think it's unfair. Let's have a look at what they really mean. I've done this before, but I do it again just to raise awareness of this. Now, a non-crime hate incident means any incident or alleged incident, so it doesn't even have to have happened, just somebody said it happened, so it's an alleged incident, which involves, or is alleged to involve, an act by a person, the subject, you, which is perceived by someone else. So it doesn't have to, it's no finding of fact here. There's no decision by the police that this is an act of that kind. It is just perceived by somebody else to be motivated wholly or partly by any kind of hostility or prejudice towards a person with a particular characteristic. Now, this report apparently suggests that it will be expanded to include all of the protected characteristics, race, religion, sex, sexual orientation, disability, etc., and include all of those particular characteristics. And if this alleged incident, which may or may not have taken place, is perceived by somebody else not definitively, but perceived by someone else to be motivated by any kind of hostility in any of those regards, then it might be recorded as a non-crime hate incident against you. Now, somewhat good news that there is an updated threshold test under the College of Policing, which says that this clarifies that personal data should only be included in a non-crime hate incident record if the events present a real risk of either significant harm to individuals or groups with a particular characteristic, or a future criminal offence being committed against individuals or groups with a particular characteristic or characteristics. For the purposes of the code, a particular characteristic means race, religion, sexual orientation, disability, or transgender identity, as defined in hate crime legislation. This test will enable the police to intervene where necessary to safeguard vulnerable individuals, etc. Now, for the avoidance of doubt, a hate crime requires an underlying crime, and it only becomes a hate crime if it is motivated out of hate or prejudice towards a protected group, and that's the reason, or part of the reason, that they carried out that offence in the first place. For example, if somebody were to commit criminal damage, they damage somebody's car, they damage somebody's house, spray paint, whatever that might be, any form of criminal damage, if it is motivated out of prejudice or hate for one of those groups, that makes it a hate crime. And that is obviously treated, rightly so, more seriously than a standard crime itself. If somebody is indiscriminately scratching cars as they walk down the road and is just a bit of a rogue, then that is criminal damage to each and every one of those vehicles. But if they are doing it specifically, let's say that they are doing it outside. I've seen vandalism reports of mosques just recently. That is quite clearly criminal damage because they're spray painting on the walls, and it is quite clearly a hate crime because it's clearly, in my view, motivated out of hate towards that group. So that would be a hate crime of criminal damage. But what we're talking about here with non-crime hate incidents is there is no crime as such, because if there was, then it should be prosecuted as a crime. But it's just an incident or alleged incident. So it is only where the police are given a report that something is supposed to have happened and it's perceived by somebody to be motivated by prejudice towards one of these groups. Now you see the problem with that, because that is a dangerous curtailment of free speech. It flies in the face of judgments that we've seen already, which says that you are free to say something that is offensive to other people. And the freedom, as the judgment says, only to speak inoffensively is not really a freedom worth having. It's not really a freedom at all. So I personally think these non-crime hate incident reports are a serious problem. It could be reported without any real investigation, without any real finding of fact, certainly not by a court or any proper judicial scrutiny. And reportedly, there are over 13,000 incidents logged in the last year, including against school children because they've made a comment towards each other in the classroom, or even vicars and doctors. I've spoken about these before. They've had these recorded against them, and they don't involve any sanction. It's not an actual criminal record, but it does show up on an enhanced disclosure and barring service check, which obviously might affect future employment prospects, or the prospects of, for example, being insured to teach martial arts or sports of any kind and things like that. Because your insurance company might then say, do you have any non-crime hate incidents recorded against you? Because I can pretty much guarantee, my personal opinion, that if these become the norm, then insurance companies will see that as a risk, because that's what insurance companies do. They insure an event, and that becomes an insurable event. Something has to happen. And the way that I describe this to people is, if your wall just happens to just fall down by itself, that's not really an event. If somebody crashes into it and it falls down, that's an event. So that's the difference. But they insure events like that. And so if these non-crime hate incident reports become the norm, I can pretty much guarantee the insurance companies will say, well, that's a risk, because one person that has one versus one person that does not have one is more of a risk than the non-hate incident reported person. And so that will become an insurable risk. And so that insurance premium will go up. So these knock-on effects will be far spread and wide. And they might even refuse to insure you. So, if you had 4 or 5 hate incidents reported against you because of your social media posts, and the insurance company requires you to declare whether you have any of these reports, let's say you're a football coach or anything like that, if they require you to disclose that and you say yes, they might then refuse your insurance. I am here warning on the 28th of January 2025 that that is something that will probably happen if these really do become the norm. I think these are dangerous. I think they curtail our freedom of speech and they should be scrapped altogether. That's my view, but that's what this leaked report apparently from the Home Office says. So let me know what you think about that. Please do remember to like the video and subscribe and share the video and all of that sort of stuff, because I am independent. I depend on you. I thank you all so much for subscribing thus far. Well over 700,000 subscribers now. I am on my mission to 1 million subscribers. So I thank you all so much for watching.